Good morning, everybody. Welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the program where we cover the most interesting live trials and legal stories in the news today. Wow, what a start right now out of Michigan. So let's get some perspective. Joining me is juvenile judge and trial attorney, Judge Ashley Willcott. Ashley, great to have you back here on the program. I'm curious your thoughts about this preliminary hearing. A little bit different. Do preliminary hearings always work like this?
No, they don't always work like this. A, you're right, they typically don't have opening statements. And B, typically only the prosecution presents evidence. But as I understand it, the defense might also produce evidence in this preliminary hearing today.
Now, the way that I understand it is they're trying to present enough evidence to go forward to see if there is a trial. That standard, though, is more likely than not. So based upon what we've seen so far from the prosecution and the defense's argument, if you were sitting there, the judge here, based just purely on the arguments presented, is it more likely than not Luanna Simon lied to the police?
Well, the more likely than not is a very low standard, Jesse. So that's an easy one, quite frankly, for the prosecution to prove. I would still need to hear the evidence, but based on the opening statements, I do think they can prove more likely than not that low standard to at least then proceed to trial.
You know, we're waiting for the feed to come back. We just heard the statements from both the prosecution and the defense. Interestingly, the defense said that this was a political move to go after Luanna Simon. And okay, we're getting a report right now that a survivor, Amanda Thomas-Show, who we covered here during the Larry Nassar sentencing hearing, she is about to take the stand. We're going to go live into this preliminary hearing out of Michigan. Remember, she is the one who said that Larry Nassar sexually assaulted her. Let's go live. It's a little bit like deja vu. We remember when these survivors were testifying in the sentencing hearing for Larry Nassar. I want to get some perspective right now from juvenile judge and trial attorney Judge Ashley Willcott. Ashley, this witness is interesting because at the beginning of the day, the defense didn't want her to testify at all. They felt that this was going to be prejudicial in a way, testifying in an upcoming trial, because they said that this is going to be, you know, this isn't about MSU's culture. This isn't about what MSU did. This is all about whether or not Luanna Simon lied. What did you think of their argument? The judge is permitting this testimony and probably she will be allowed to testify at an upcoming trial, but I'm curious your perspective.
Okay, so here's the thing, Jesse. You're right in what the defense is arguing and why this shouldn't have been a witness in this case. Bottom line, here's the narrow issue. It's a very narrow issue. Did defendant Simon know in 2014 about the allegations and then lied to the police? That's the narrow issue. This witness can provide the context and details around who she disclosed to, who was involved with the meetings, and who knew about the allegations. So that aspect of this testimony is directly relevant to the state's position for today's purposes.
And even more interestingly, we believe the defense will have an opportunity to cross-examine her, which is something we haven't seen before. Let's go back live into the courtroom right now. Now, Ashley, here's the interesting part about her testifying. The defense will have the opportunity to cross-examine her. We've never seen this before, a survivor cross-examined quite like this. It didn't happen in the Larry Nassar sentencing. What can we expect?
Well, that all depends on the personality of the defense attorney who's going to question her. That attorney needs to be really cautious and use kid gloves, because regardless of the information they're trying to get out on cross-examination, they do not want to appear to be attacking the victim. I think the defense cross-examination could be and should be fairly short, because, again, all they want to show is that it's not more likely than not that this person, Simon, knew about the allegations in 2014.
Yeah, okay. Let's take a quick break. When we come back, we'll learn a little bit more about what happened back in 2014. Let's take a break. Okay, Ashley, there's a lot of moving parts in this case. Timeline is huge. The idea here is knowledge, right? Did the defendant have knowledge about Larry Nassar and sexual assault back in 2014, which means she misled investigators, lied to investigators about when she knew about it? But knowledge, proving knowledge, is that tough? Is that a tough thing to prove in a case?
Well, first thing they're doing right now is proving that there was an incident of sexual assault in the time frame, which is 2014. That's the first step. Now, the next step, knowledge, anything can indicate knowledge, whether it's she was present at a meeting, whether someone said, we have told her, whether it was through a phone call, something in writing to her. Any of those things can demonstrate knowledge. So there are lots of ways for the prosecution to prove, theoretically, that she knew about this assault.
And both sides have conceded that she made the statement that she knew about a sports medicine doctor. But the question is, did she know it was Nassar? And the details of it becomes the real big question. And really, one of the biggest issues is, was she even at a meeting? Was there even a meeting between her and, the head of the Title IX office? Let's take I think we have to take a quick let's take a quick break, and when we come back, we'll be live in that courtroom. So stay tuned here on Law and Crime. I want to get your perspective on this right now. There seemed to be breaking the tie between her statement, her report, and what Simon knew. I'm curious your thoughts on this examination.
That's exactly right. First of all, trauma-type cross-examination, trauma-informed, so imperative. This defense did an excellent job at saying right out of the chutes, we're so sorry, no, this is difficult, not going to ask you the details about what happened. Next, he's gone straight in to prove exactly what you just said, Jesse, no communication of any kind with the defendant, Simon, which is the whole point of this preliminary hearing.
And it's all up to the judge in this case to determine if there is enough evidence presented to go forward with a trial. Let's take a quick break, and we'll be right back. Welcome back, everybody. We are covering the preliminary hearing in former MSU President Luanna Simon's case. Again, she's been charged with lying to police about when she found out about the Larry Nassar sexual assault allegations. I'm back here with Judge Ashley Willcott. During the break, Ashley, what we saw was a final questioning of Amanda Tomashow, one of the survivors of Larry Nassar's abuse. And the question really directed to her, do you have any knowledge that the report that you gave, this complaint, was it ever given to the defendant, Luanna Simon? Do you know of that? Do you have any knowledge? And she says she did not. But she did provide some commentary that she said she's expecting, she would assume that a university that values reporting sexual assault, especially as she said that Luanna Simon had given a speech back in 2012 about it, she would assume that Luanna Simon would have had it, but she doesn't know personal knowledge. What I'm getting the sense of throughout this whole case is it's very hard to separate the mistakes made by MSU and the actions of Luanna Simon. Are you feeling the same thing?
At this point, yes, but keep in mind there's some wiggle room. So this victim did testify. She has no idea. On the very first phone call, when she initially reported this to Christine Moore, she has no idea who else was in the room, who else was on that call. So there's an opportunity. Who knows? The prosecution may say, listen, this defendant was in the room for that call. So there are windows of opportunity for the prosecution to still say, this witness victim wouldn't have known, but Moore was put on notice. She knew. I mean, excuse me, not Moore, the defendant, Simon.
You know, it's interesting. So we just got a report that the preliminary hearing is done for the day. It will be back April 9th. What happens between now and April?
Nothing. I mean, it's so frustrating. I know from the lawyer's perspective as well as the viewer's perspective, because I'm assuming it was based on a court scheduling need, and so there's nothing that happens between now and then. This victim certainly is going to be advised she can't speak to any of the other witnesses in the case or talk about the case or talk about her testimony, and the attorneys may do a little additional preparation between now and then, but now we're just waiting to have the rest of this preliminary hearing, Jesse.
It's been an interesting day to follow. Different kind of preliminary hearing. Again, the idea is, was there evidence presented where it would show more likely than not that she lied to the police? And let's start right now, in case you're just joining us, so you want to recap with the prosecution's, I would call it an opening statement in the preliminary hearing from earlier today. Take a look.
Like great people have to do more than look good. They have to be good. They have to choose to do good. And that didn't happen here. Since 2005, the image of MSU and the defendant have been linked together with an unbreakable bond. That's when she took over as president of MSU. When MSU looks good, the defendant looks good. In April 2011, as I mentioned in my response to the motion, MSU and many other schools received what was called a Dear Colleague letter. The letter was from the Department of Education Office of Civil Rights. The letter recommended that schools implement a number of changes in handling sexual misconduct on campus. MSU personnel, including Paulette Granberry Russell, that you'll hear from during this preliminary examination, began working on implementing some of the recommendations. They adopted some policies, they did some training. It was a high enough priority that the Title IX implementation became a regular agenda item on the defendant's calendar. In 2012, the Office of Civil Rights received 3 complaints against MSU for the way MSU was mishandling complaints of sexual misconduct. OCR, the Office of Civil Rights, became a regular agenda item on the defendant's calendar. By early 2014, the Department of Education Office of Civil Rights scheduled a campus visit at MSU to investigate their mishandling of complaints of sexual harassment and assault. Paulette Granberry Russell was the person in charge of the Title IX office at that time. And at that time, her office had 1 investigator for all of the student-on-student misconduct and assaults, and 1 for all of the misconduct and assaults committed by staff. At the same time, there were 5 trainers for just the football team. Christine Moore was the lead investigator for the staff complaints, and she worked for Paulette Granberry Russell. Paulette is a career employment lawyer, and so is Christine Moore. Neither one has law enforcement training, victim interview training, prosecution experience, or any other background that would help the victims they were dealing with. All of their training and experience was to protect MSU.
Okay, the question at the end of the day was, did Luanna Simon have knowledge about Larry Nassar and the sexual assault allegations? And I'm back here with Judge Ashley Willcott. Ashley, what I'm seeing is a chain here from Thomas Show to Christine Moore, who was a Title IX investigator, to this other woman, Paulette Granberry Russell, who then apparently was supposed to be setting up a meeting with Luanna Simon. And then the question becomes, was there even a meeting between Russell and Simon? Because that seems to be the crux of the whole case. And one of the ways that they've indicated this is that apparently there was this folder that had Larry Nassar and sexual assault on it, but Luanna Simon's defense team said, at the very least, we don't even think there was a meeting, but if there was a meeting, it was probably over the phone. So is this all boiled down to a meeting?
Well, no, not necessarily. First of all, Simon says definitively there was no meeting, so the prosecution would have to have some kind of evidence that the meeting occurred. But keep in mind, Jesse, the only way any of us have knowledge about anything is if someone told us. So whether it's in that meeting or, again, it could have been by an email, by a verbal report, by a phone call, by a text. Any of that imputes knowledge that she had knowledge. So it's not just about the meeting, it's about any other source of information provided to her, putting her on notice, giving her knowledge of this report.
Do you think that there's enough evidence to move forward with the trial?
Not at this point. We haven't seen it at this point. Granted, I think we have 2 more days scheduled for the rest of the preliminary hearing, but based on the victim's testimony alone, absolutely not.
But at the end of the day, isn't this a question for a jury to ultimately decide? I mean, there seems to be evidence that she may have had knowledge. And if she may have had knowledge, isn't that enough? Isn't that enough to put in the hands of the jury and say, hey, you determine whether or not beyond a reasonable doubt she's guilty of having this knowledge and lying to police about it?
I don't think so under our current justice system, because the preliminary hearing is the state has to have enough evidence to even be allowed to put it to the jury, right? So this is a safeguard, protects constitutional rights. If they can't get past this super low burden of more likely than not, then they shouldn't go to trial because they don't have any evidence to prove that it happened.
Obviously, this is a horrible situation from multiple levels, and clearly there was a mistake made that this abuse went on for years and that it wasn't addressed properly. But the defense attorney made the point that she has been charged, Luanna Simon, for a political reason. She's charged so late in the game. Do you believe there's a political reason here for her being charged?
I don't think that's the only reason she would be charged. I believe the state does have evidence that we haven't heard yet that something happened that put her on notice in 2014, that there was some type of communication to her that put her on notice. So I don't believe that's the only reason the state of Michigan would choose to go forward.
Well, I'll tell you this much. There's probably a lot of people, including the survivors of his abuse, who are happy to see at least these questions being asked and these people being grilled, and now she is facing some serious charges herself, and there are answers that need to be that need to come forward about what happened, who knew what, and why did this go on for such a long time. We're going to take a break, but when we come back, we're going to switch gears and focus on the Cheyenne Harris trial in Iowa. We'll be right back. Okay, let's get some perspective right now on this case because there's a lot to consider. So joining me back with us is juvenile judge and trial attorney, Judge Ashley Willcott. Now, Ashley, what we're hearing really is it's important to know when Sterling died, but in terms of time frame, it's also important to know how long he was unattended for as well, right? I mean, it's not whether or not he was dead for 8 hours or 2 hours or a few days. When did the neglect start? For me, I feel that's the bigger question, but I'm curious your perspective.
Absolutely agree with you because the neglect caused the death. This bug expert has just testified that the infestation happened 13 days before the death. So that's a 9 to 13-day window that any person caring for the baby should have known and realized the diaper needed to be changed, he needed attention, he was being neglected.
As we're talking, we're playing some footage of Cheyenne Harris getting extremely emotional during the course of this trial. People might be surprised to see this in light of what she's been charged with, neglecting her baby. What do you make of the fact that she's showing such emotion in the courtroom? And remember, her defense today, we believe, is going to be a combination of mental disease, substance abuse, depression, postpartum depression. I'm curious your thoughts on seeing this.
Listen, I've been watching this trial very closely, Jesse. I know you as well. You've been covering it as the host. She had not been showing a lot of emotion. And if you look at our chat room, there are people who say that they could see her smiling under her hand. So to me, I'm struggling believing the credibility and how upset, distraught she's getting. She saw it firsthand. I'm not buying that those defenses mean that the entire time she had this baby, she was so incapacitated that she didn't care for the child accidentally. I'm having a hard time buying the display of emotion that she's showing. I think she's probably more upset that she got caught than she is hearing about what happened to her own baby.
Ultimately, it's up to the jury who's watching her day in and day out to make that decision. And we're going to have to ultimately see. Maybe she'll take the stand, maybe she won't. Probably not, but we'll have to see. We are going to take a quick break. When we come back, we have more to discuss in the Cheyenne Harris case in anticipation of our live feed at 12 p.m. We'll be right back. Those are the words of the defendant in her police interrogation tape. We always look to see that in any trial. Words from the defendant, whether they take the stand or they were in a police interview, definitely provides some insight. And speaking of insight, let's get some more insight from Judge Ashley Willcott. Now, we are expecting the defense to begin their case today in about a half hour or so, Ashley. What do they need to do to, at the very least, convince this jury that she's not guilty of first-degree murder? What do they need to show?
They have to show, it's called the intoxication defense, or diminished capacity. So they have to show that she was either under the influence, substance abuse addiction, and or mental health issues. And that can include postpartum depression, those things. But they're going to have to prove that. But Jesse, here's one of the biggest pieces that bothers me about this case. You just heard in her interview, in spite of claiming that defense, she can articulate the great care that she took of her 2-year-old toddler at the same time her baby was being neglected.
Now, in other words, you're saying in order to establish this, and correct me if I'm wrong, there needs to be some, for the state, there needs to be some element of intention. There needs to be some element that's deliberate, willful, that they knew what they were doing when they were neglecting this baby. But you're saying that's going to be hard to argue Because what is she arguing the other way? That she was taking care of him? Well, clearly she wasn't. The baby died. So how are they going to argue that exactly? You know, how are they going to show this wasn't intentional or deliberate, that she was just so affected by meth and that she was so affected by postpartum depression that she went into a haze? Am I understanding that correctly? Because at the end of the day, there was a 2-year-old in the house who was okay.
Right. Well, that's the problem. The 2-year-old that was okay. Not only was the 2-year-old okay, Jesse, that 2-year-old, she took amazing care of the 2-year-old by all accounts. She can tell you every single thing she did with that child, fed, clothed, not sick. I mean, that's the discrepancy, is to say, listen, she was under the influence and didn't take care of the infant, but yet at the same time she didn't take care of the infant, neglected to the point he died. She did take this amazing care of her 2-year-old. Those things don't go together.
Yeah, there's strong arguments from both sides. It's going to be an interesting day in court nonetheless. Judge Ashley Willcott, thanks so much for coming on.
Thank you, Jesse.
All right, everybody, let's take a break. We'll be right back. So powerful. Now, today, again, was the preliminary hearing in Luanna Simon's case. If she's found guilty, this is a very serious charge right here. I want to get another perspective. And joining us back, she stayed with us. I was incorrect. Judge Ashley Willcott is back with us. Thank you so much for staying on. And to talk about this, what a day it's been to watch Luanna Simon in that courtroom. Some would say very surreal in light of the comments that were made during that sentencing hearing, which were playing months ago. I find it very incredible to see where we've come. And again, this is all allegations that she's lied to police, but the very idea that questions are being asked from some high-ranking officials and that she was forced to resign and there's an investigation to how all this happened, it seems, Ashley, in my perspective, it's just a testament to the young women that came forward.
Oh, I completely agree. We heard how powerful their statements were, Jesse, and that's exactly this investigation into this, whether or not there was a cover-up, is exactly what needed to happen. And it's also disturbing to note some of the descriptions they gave, that here we have Luanna Simon, who said initially, oh, I was too busy to come for the victim impact statements. It's like she has not done anything to support these victims throughout the entire process, which adds insult to injury.
You had mentioned conspiracy, and I want to touch upon that. We had talked earlier about the charges that she faces about lying to police. It might not be so clear-cut that she lied. Why wasn't she charged with something else? You talk about a cover-up. Why not a conspiracy charge or something like that?
I think that the elements are so different in the two. Lying to police, you only have to prove that she knew, she actually had knowledge and failed to disclose and lied to the police about it, versus a conspiracy where you have to show that there was deliberate actions between her and other staff employed by MSU that conspired to hide the charges. And so those are very different elements to have to prove. I'm assuming the state didn't feel like they had evidence to be able to charge her with something like conspiracy.
It's interesting to watch, and we'll see which way it ultimately goes. Again, we expect new development next time in April. That'll be the next court date. In the meantime, let's take a break, and when we come back, we're going to focus on Cheyenne Harris. I think I see some activity in the courtroom. We'll be right back. Okay, we have some things to talk about right now. Ashley, first thing I want to talk about right now is the idea that Zachary Cohen's testimony is apparently going to be read into the record. He's not going to testify, but what he testified to in his trial is going to be read, and the state and the defense
is unavailable. Under a certain definition of unavailable, you can use prior testimony. So he is unavailable by virtue of the fact he has stated he would take the Fifth Amendment right against self-incrimination, so he would not answer any questions. He therefore is unavailable, so they can utilize the prior transcript, and they will do that in forms of either having it read or, if they want to do by stipulation, simply present it in writing. But I think it's going to mean they have it read as well as present it in writing to the jury and published so the jury has that.
And now we also learned one last thing about the expert. The expert that we believe the defense is going to call it seems the testimony is going to be a bit limited. In other words, for example, the expert testimony is not going to say it excuses her behavior at all, but just shows what she was going through. So what's the defense going to do here?
heard, because that's exactly what it does. I expected, and they said in their opening statement, remember, Jesse, in the defense's opening, they said they were going to argue diminished responsibility. And now what we've heard them say is, no, we are not going to argue that. Our expert's not going to say that. All we want to do is be able to say to the jury, this is her diagnosis. I don't know why they've gone from saying diminished responsibility to simply this is her diagnosis. Something's changed in their strategy, in my opinion.
It seems the same thing. Something has changed, but at the same time, who knows what the jury will ultimately take from the testimony, regardless of what the expert says. If they hear that she has been suffering from something, perhaps they'll feel sympathy for her in a way and not vote in favor of first degree. We'll have to see. I know we have to sign you off now, though, Judge Ashley Willcott. So thanks for coming on and staying with us. All right, everybody, so we're going to take a break. I'm signing off. Vincent Hill is signing on, and he's going to guide you through our live trials of the day. Stay tuned here on Law and Crime.